Hello friends, this is Pami Jaiswal and I'm a practicing company secretary. Today, I'm going to deliberate on the topic understanding CSR for NGOs. This deliberation is slightly different from my previous deliberations at various forums because previously the intent was to make the corporates aware what are their actionables or what they are expected to do out of the changes that came under the provisions of section 135. However, in this video, I have tried to conceptualize the basic concepts of the CSR and the requirements which are there for the NGOs, which they need to comply before they approach the companies or when companies make or route their CSR through these NGOs. So let's get started. So when we are talking about understanding CSR for NGOs, we are saying that NGOs are playing a significant role because they are at the ground level. They are working at the ground level to implement the activities and make the companies achieve the objectives of CSR. So talking about the background, when companies were required, when the companies started complying with the concept of corporate social responsibility for the first time, that is when it was introduced under the Companies Act 2013 in the year 2014, it was a comply or explain provision. Why I say that? The reason is that as per the erstwhile provisions, a company which was covered under section 135, but which did not or was not able to spend the required budget for CSR was required to give a reason for not spending in the board's report. However, following the series of amendments that have come in, and specifically the provisions of corporate social responsibility under the Companies Amendment Act 2019, which got notified on 22nd of January 2021, the provisions have changed its flavor. The provisions have become comply or explain to comply or pay penalty. So after this notification, companies will have no escape. Companies will mandatorily be required to spend the minimum budget, which is 2% of the average net profits of the preceding 3 financial years. So let's understand which companies are actually covered under corporate social responsibility. Companies on which section 135 of the Companies Act is applicable are those companies which meet any of the following thresholds. When I say any, that means if it meets either of these thresholds in any preceding financial year, they will be covered under section 135 and hence will be required to spend the minimum budget of CSR. The requirement is to either have a net worth of rupees 500 crore or more, or a turnover of 1000 crores or more, or a net profit of rupees 5 crores or more. Most of the companies get covered under the third proviso, third threshold limit, which is a net profit of rupees 5 crores or more. So what is expected from a company which gets covered under section 135? In a very brief note, let me tell you, any company which is covered under section 135 is required to set up a CSR committee, is required to formulate a CSR policy, is required to fix CSR budget and also approve the allocation, and of course make the CSR spending and carry out the monitoring exercise as well. After the amendment, it will also be required to formulate an annual action plan. What are the means to spend for CSR? When I say means, is when a company is covered under section 135 and it has constituted a CSR committee, it has formulated a policy, it has identified that these are the areas where I'm going to spend and this is the amount that I need to spend. So how will it spend? What are the means, or what are the means that the Companies Act provides to a company to spend? So friends, a company can carry out CSR activities directly or through captive agencies. When I say captive agencies, I have used this as a reference term. I mean to say agencies like trust, society, or Section 8 company, which are settled or which are incorporated by the company which is covered under 135. It can also carry out its CSR activities through government agencies. Government agencies also, it can carry out CSR activities through public agencies. When I say public agencies, it means trust, societies, Section 8 company, which are not settled by the company. And therefore, these are the anonymous bodies. So they are not settled, or they are not formed by the company. They are public charitable bodies set up by any other person, to be specifically called NGOs. As per the study of the KPMG on top 100 companies in the year 2019, it was seen, it was observed that out of 100 companies, 75% of the companies carried out CSR through partnerships, whereas 18% of the companies carried out CSR through their own foundations. So we can understand that NGOs play a very vital role. The NGOs, it does not mean that companies only carry out CSR through their own trust or society. It also carries out CSR activities on a large scale through public NGOs. So therefore, it becomes very important for such NGOs, for such public NGOs with whom the corporates are not, otherwise in sync, or they are not. So these NGOs have a lesser opportunity to know about the requirements of the corporate social responsibility provisions as compared to those captive agencies with whom the companies are anywhere engaged. So what is the role of the NGO in carrying out CSR? NGOs play a very important role in implementation of the CSR activities of the company. That means it helps the company in actual implementation of the project or the activities, and therefore we can refer them as implementing agencies or IAs. Let me give you an example. A company which is covered under Section 135 is required to spend on certain activities or areas which are covered under Schedule 7. So if it wants to spend, it can contribute the budget, a part of its budget, to an NGO, which in turn, let's say, has been doing work in the field of education, and it has been providing necessary supplies to several schools in the rural areas, for example. So company is going to give the money to this NGO, and this NGO, which is having a track record of previous 3 years in the same field of promoting education, creating awareness about education, makes or routes the money to several schools in the rural areas, which by which the money goes into the for the objective for which it was actually approved, that is promoting education. Taking another example, if the company has decided to contribute in the area of healthcare, and it has approved a budget for the same. So a company can contribute a certain part of its budget to an NGO which has been working in the field of healthcare awareness. And when the NGO receives the fund, the NGO will, as per the directions of the company, route the money or put the money, give the money to those hospitals or to those, let's say, health camps, which are set up by several other hospitals, by which the objective of promoting healthcare is met. This is one way or one of the roles which NGO plays. Next is through a crowdfunding platform. When I say an NGO acting as a crowdfunding platform, what does it do? We'll understand this little later in the slides, but just to give you a brief, it acts as a connection link between the company and the beneficiary or the implementation agency. It collects a fund for specific cause and helps companies routing funds for the said cause. Thirdly, NGOs also play a very important role in being the beneficiary. For example, an NGO runs schools. So if an NGO runs schools itself, and the company contributes money to this particular NGO, it does not mean that the company is implementing it through an agency. It means the company is contributing the money to an NGO, which is actually a beneficiary. That means if this amount goes from the company to the NGO, which runs the schools itself, there is no case of giving the money to an implementing agency. Here, the company is doing a direct CSR. So companies may contribute funds based on activities of the NGOs that are engaged in, and NGOs may use it for the furtherance of their objectives. Which agencies can act as an implementing agency? So let me clarify this, friends. As per the requirements of the rules, whether it is a captive agency or a public agency, we mean an agency which includes a registered public trust, registered society, or a Section 8 company. Plus, an implementing agency can also be certain government institutions. However, there are requirements for a public agency being a registered public trust, registered society, or a Section 8 company to have a track record of at least 3 years in carrying out the activities mentioned under Schedule 7. In any of the areas mentioned under Schedule 7, to be eligible to carry out a particular CSR activity in the same field. However, this track record requirement is not needed for captive agencies. That means those agencies or those registered public trust, Section 8 company or a society which has been settled by the company itself, either by themselves or along with any other company. As I mentioned, NGOs can also play a role of a crowdfunding platform. Let us see how. Crowdfunding platform, as I mentioned, acts as a connecting link between the companies and the ultimate beneficiary or an implementing agency. They are doing the work of filling the gaps of the information asymmetry between the ones who are ready to contribute the funds and those who are in need of funds. They collect the funds for a specific cause, and as long as the funds are being collected for a purpose or for an objective or for an activity which is covered under a CSR or which is an eligible CSR activity, in my view, there is no reason for companies to not come forward and contribute through these crowdfunding platforms for fulfilling their CSR obligations. While there is no specific explicit clarification from the MCA in this regard as to whether they accept a crowdfunding platform, as not as an implementing agency or as otherwise, or they disentitle them by some means. It is very important to understand that we need not take a very narrow interpretation of saying that a crowdfunding platform is an implementation agency. Crowdfunding platform is not acting as an implementation agency because they are only acting as a platform to link or to connect the ones who are actually need of funds. That may be the beneficiary or that may be an implementing agencies, and the corporates which are required to have to fulfill a CSR obligation. As I mentioned, Schedule 7 of the Companies Act 2013 has the prescriptive list of items which can be carried out under CSR. This is not the exhaustive list because MCA from time to time brings various clarifications and includes certain items for certain time periods or permanently, looking at the need of the time. For example, during the ongoing pandemic, MCA has brought several clarifications, has brought several circulars where it has included activities in relation to COVID relief or creating awareness about vaccination or research about COVID-19 vaccines as a eligible CSR activity. Activities that can be carried out as a CSR So as we have seen, there are various activities under Schedule 7, which are eligible CSR activities. So NGOs having objectives in line with the requirements of Schedule 7, which it may include promotion of education, healthcare, protection of environment, restoration of culture, handicraft promotion, disaster management, development of slum area, development of rural areas, and promotion of sports, to name a few. So NGOs which are engaged in furthering these activities are very well eligible to approach the companies for, for furthering of their objectives. And companies are also should not have any issue or should not have any reason for denying denying to contribute to such NGOs. But we need to understand that only carrying out these activities as CSR is not the only requirement for an NGO which is acting as an implementing agency. There is a very, very important requirement that we need to understand as an NGO before we approach the companies. Let us understand what are those. Registration requirements. So friends, following the amendments that came in that came on 22nd of January 2021, there are several registration requirements which the NGOs which are acting as an implementing agencies and not the beneficiary, but implementing agencies are required to get before they approach the companies. Registration with MCA by filing CSR 1. So this form is required to be filed by all the implementing agencies before they act as an implementing agencies. Specifically, with effect from 1st of April 2021, all implementing agencies, or I can say the NGOs, which are acting as an implementing agency, need to file this form and register themselves. This is mandatory so that they can act as an implementing agency, and this will attract more companies since both they can act as an IA as well as beneficiary. The other requirement of registration is registration under the Income Tax Act, the registration under Section 80G and Section 12A. These two registrations are required for the agencies like trust, society, and Section 8 company, whether public or captive, because this will also have the benefit of giving tax exemptions to these agencies. And thirdly, registration under specific state laws. For example, in case of a trust, if in case of a public charitable trust, there's a need that they need to be registered. So there are state specific laws. For example, in the state of Maharashtra, if we are forming a public charitable trust, then we are required to get it registered with the registrar of assurances. It's a mandatory requirement. Whereas in the state of West Bengal, this registration is not mandatory. Therefore, is it that if in the state of West Bengal, my trust is not registered with the registrar of assurances, it will not be qualified to be a registered public charitable trust? The answer is no. It will still be qualified to be called as a registered public charitable trust, because as per one of the MCA's notification in the year 2014, in a registered trust means a trust which is registered as per the state specific laws, and for states where registration is not mandatory, their registration with the Income Tax Act or under the Income Tax Act will also be sufficient to make them fall under the definition of a registered trust or a registered society. What are the other requirements? So the other requirements are maintenance of proper books of accounts. Why? Because any amount which the company gives to the NGO is not given and forgotten. Any amount which is given has to be monitored by the company. And that is why for proper monitoring of CSR activities, the monitoring report will be required, and for which proper books of accounts are anyway needed. Utilization certificate. Even if you are not an implementing agency, but a beneficiary, in that case also, when you receive funds from a company, you need to give them a utilization certificate or an acknowledgement as to where this money is going to be used. Another very important aspect which NGOs should understand now is the concept of ongoing and not ongoing project, because it is linked with the unspent money. So let us understand, where the company disperses the fund to the NGOs to be utilized on a specific project or activity. And at the end of the financial year, a certain part of the amount remains unspent. In that case, the NGOs will be required to either refund the money back to the company or act as an authorized representative or an authorized signatory on behalf of the company to transfer that unspent amount to the bank account. So what is the role of an ongoing and not ongoing project in this case? The answer is that as per the amended provisions of the corporate social responsibility, if a company has contributed for an ongoing project, in that case, if any money lies unspent at the end of the financial year, the unspent amount will have to be transferred to the unspent CSR account within a period of 30 days from the end of the financial year. Whereas if the amount has been spent for a project which is not ongoing in nature, in that case, the money will have to be taken back from the trust or the society or the NGO, to be specific, and the amount will have to be transferred and put in the fund which is given under Schedule 7. Now let us understand the difference between an implementing agency, beneficiary versus a crowdfunding platform. Let us understand this, that an implementing agency is required to mandatorily get itself registered with MCA as well as the Income Tax Act, right? Whereas in case of a beneficiary, where an NGO is acting as a beneficiary or a crowdfunding platform, the registration is not mandatory. However, we'll hardly find an NGO which has not registered itself with the income tax, under the income tax, because there are two benefits. One is for those who are contributing, they get they get tax exemption, and of course the particular NGO, they being in the form of a charitable organization, their income is also exempted if they are registered under the particular provisions of the Income Tax Act. What is the benefit? In case we get our CSR activities, the company gets its CSR activities implemented through an implementing agency, it helps in a proper implementation, because company cannot put all its time in getting the CSR obligations implemented in efficient manner. So there the implementation agencies play a very important role. In case of a beneficiary, it uses the CSR contributions of the company for the furtherance of its own objects, because they are themselves the beneficiary. And in case of a crowdfunding platform, they collect the fund for a cause supported by the company. What is the role? Implementation agencies act as an extended hand of the company. They act as per the directions of the company, right? In case of a beneficiary, they act as a recipient of the money, because they use the money for their own objectives, which are covered under Schedule 7. In case of a crowdfunding platform, they act as a connecting link between the company and implementing agency or a beneficiary. Spending discretion. In case of an implementing agencies, they don't have their discretion. They cannot exercise their discretion. The discretion will be that of the company, because the company is the principal and the implementing agency is the agent. Whereas in case where the money has gone to an NGO, which is acting as a beneficiary and not an implementing agencies, in that case, the spending is as per the objectives of the beneficiary and completely on the beneficiary. Crowdfunding platforms collect the money and they provide it to the IE or the beneficiary as instructed or as per the scheme which is floated or the campaign that is floated. Monitoring requirement. When we talk about the monitoring requirement, in case of an implementing agencies, monitoring and utilization reports are required. In case of a beneficiary also, utilization certificate will be required. And in case of a crowdfunding platform, there are no such requirements. However, when a company contributes money through a crowdfunding platform, the money gets surely given to the implementing agency or the beneficiary, which in turn should be giving a utilization certificate or a monitoring certificate to the company. So this was a brief deliberation on certain important aspects of corporate social responsibility, which an NGO should know before they approach the company. Thank you so much for the patient hearing. And I will be really glad if I receive feedback or any suggestion on the video. You can also post your queries in the comment section. Thank you so much.